Yes, good afternoon, ladies and gentlemen. We are so sorry for starting a little bit behind schedule. We have some challenges, but we are happy that we've been able to fix some of these challenges to a great extent. We are hoping that subsequent outings will be better. You are welcome to the maiden edition of the online lecture series being organized by the law firm of Chukwunonso Daniel Ogbe and Company from Enugu State of Nigeria. You are highly welcome. I remain myself, Mr. Chukwunonso Daniel Ogbe, the principal counsel in the law firm of Chukwunonso Daniel Ogbe and Company, Enugu State, Nigeria. So this is a online lecture series will last for 3 days, subject to what happens at the end of the day. In which case, if there is need for us to elongate this particular session, we will do that. But we are hoping that in due course, that apart from today, that the remaining 2 days that this online lecture series is expected to take place with regard to the rights of landlords and tenants in Enugu State of Nigeria will be enough to address all the concerns of our dear listeners. And as was rightly noted in the course of advertising this particular online lecture series, we made it known that those who may have questions to ask in due course, they can subscribe to our YouTube channel, being CD Ogbe TV. Thereafter, you can listen to this particular conversation. I call it conversation because we look forward to your feedback in due course and also ask your questions. So you are highly welcome. And we also hope that we'll be able to attend to other areas of law in due course as well. But today, we shall be looking at the rights of landlords and tenants in Enugu State of Nigeria. And in doing this, we are going to look at several different issues today. And we are going to take them one after the other. And as I believe most of us know, we also have some other persons, some other resource persons who will be part of this exercise, including Lillian Okolo, who is of this same law firm. We also have Edwin Arum, who is a lecturer, a law lecturer of University of Nigeria, Enugu campus. But today, I'm going to be the one to talk to us today. So today, basically, we are looking at we'll be looking at several different issues, and I'm going to take them one after the other, as far as the rights of landlords and tenants is concerned in Enugu State. Now, the first thing we are looking at is the ambit of the landlord-tenant relationship in Enugu State of Nigeria. The ambit of landlord-tenant relationship. Likewise, we are also going to look at, we are going to examine those who are qualified to act as landlords and tenants in Enugu State of Nigeria. I am going to marry these two issues because they are interrelated with each other. The two issues are interrelated. So the first point to note is that the law that governs the relationship between landlords and tenants in Enugu State is unique. This is the problem many people normally make, or the challenges some people normally encounter whenever issues are being contended with regard to the rights of landlord and tenants. The law that applies to Lagos State is not the same as the law that applies in Enugu State. In other words, the rights of landlords and tenants is state-specific. When I mean state-specific, Enugu State has its own special law that regulates the rights of landlords and tenants. And that law is known as the Landlord and Tenant Law of Enugu State 2004 as amended. This particular law has undergone series of amendments, but the comprehensive part of this law will be found in the 2004 law made by Enugu State House of Assembly. Likewise, the various amendments made thereafter are very vital, of course, in appreciating the ambit of the rights of landlords and tenants in Enugu State. So we should bear this in mind, that the manner in which a landlord is to enjoy some rights, same with a tenant, maybe in a state like Ebonyi State, differs from what obtains in Enugu State of Nigeria. Now, having said that, anybody can be a tenant. In other words, a minor can be a tenant. When I mean a minor is someone who is still seen as a child in the eyes of the law. Like going by the provisions of the Nigerian Constitution, anybody who has attained the age of 18 is deemed to be an adult. It's also vital to know that the Nigerian Constitution made special provision for women that any female person who is married is automatically also deemed to be an adult, especially by virtue of the provisions of Islamic religion. That's a constitutional provision. But apart from this exception, for one to be deemed to be an adult in Nigeria, one must attain the age of 18. Having said that, as I said earlier, any person, even a minor or an adult who desires to be a tenant can be a tenant in Enugu State of Nigeria. But this is not the case with landlord. A minor cannot be a landlord in Enugu State of Nigeria. However, if, let's say that a man bequeaths his property as a gift to a child, or a man in a will bequeaths his property to one of his heirs, and that heir is not up to the age of 18 years, what will now happen is that if that heir wants to enter into a landlord-tenant relationship with a prospective tenant, the heir's guardian can come in to act on behalf of that particular minor, that particular heir who is a minor, so that that minor can enter into a landlord-tenant relationship with another person through that guardian. And guardians ordinarily can assert their rights through, minors ordinarily can assert their rights through guardians, being persons who are adult persons in Enugu State and most other states in Nigeria. So this also applies to landlord-tenant relationship. So having said that, for an adult to also be eligible to act as a landlord, the adult must be in his right frame of mind. In other words, if an adult person is suffering from incapacity, such as infirmity of the mind or similar situations that make it impossible for such adult person to enter into a landlord-tenant relationship, then the adult person has to seek the help of another person who does not suffer such a disability to help him or her enter into a landlord-tenant relationship. We also have what we call joint ownership of property, in which case two persons can become landlords of a given property. Assuming two persons purchased a property and they enjoy joint ownership over that particular property, both persons can become landlords by virtue of the provisions of the law, because they exercise joint ownership over that particular property. So in a nutshell, the main points that I have been able to raise so far is that one, that the landlord-tenant relationship in Enugu State is governed by a specific law, being the Landlord and Tenant Law of Enugu State of 2004 as amended. I've also been able to raise issues on who qualifies to be a tenant. I have made it know that even a minor is someone who is not an adult. A minor can be a tenant. In as much as it's also vital to know that if a minor wants to enter into a landlord-tenant relationship, it will also be wise for an adult person to enter into that relationship on behalf of that minor. In as much as the law does not expressly prohibit a minor from entry into such relationship, yet that contract may be voidable. There is difference in a contract being void and a contract being voidable. When it is said that the contract is void, it means that from the word go, that contract does not enjoy any legal validity in the eyes of the law. But when it is said that it's voidable, in a nutshell, it means that, yes, that it may be, that particular contract can become void on the part of one party, but that party can decide to waive that particular right to declare that contract void. And then, having said that, we should also appreciate the fact that the landlord and tenant law, landlord and tenant relationship in Enugu State, in as much as there is a statutory law governing that particular relationship, somehow enjoys common law flavor. The House of Assembly members of Enugu State have codified these various common law positions. If you are talking about common law, the best way to break it down for us to have an easy grasp of what we refer to as common law is that these are laws that were applicable in England. These were laws that were in operation in England. And because of the fact that we are colonized by the British, when they came here, these laws became applicable and they continued remaining in force, except in cases where these laws have been abrogated by laws made by our own lawmakers, by our indigenous lawmakers after we got independence. That's the best explanation I can give to it. I wouldn't like to go into the full legal details because I know that some of us who are listening may not be lawyers. In other words, common law is the law that is applicable in the common realms of England, that we are applied, in the days of yore in England. And by virtue of our colonial history, these laws also became applicable in Nigeria. But after we became a sovereign nation, these laws are not are still operative with regard to areas where we are yet to make laws to take care of certain issues. Assuming there is a law, a common law that governs maybe the relationship between a man and woman, and we are yet to make any similar law in Nigeria, then that law continues being enforced. However, once we make any law that regulates that particular field of endeavor here in Nigeria, automatically the common law ceases to have effect. Having said that, in as much as the Enugu State House of Assembly made a law, being the Landlord and Tenant Law of Enugu State of 2004, if you go through the contents of that law and just suppose same with the provisions of common law, you find out that most of the provisions of this particular law are in all fours with common law principles guiding landlord and tenant relationship in England. Now, having said that, another point we have to note is that being one of the issues we are going to address is that the nature of tenancy recognized by law in Enugu State. Now, before we talk about tenancy or landlord-tenant relationship, there is something that must be in existence, and that is what we refer to as a property. There must be a landed property in existence. And that property mustn't be a building, even though most of the properties envisaged in this regard have to be building. Any makeshift that is or any immovable makeshift that is in existence owned by an individual could be in the eyes of the law regarded as a property in Enugu State, in as much as that particular makeshift structure is able to afford accommodation to a desirous citizen. So, having said that, we have to appreciate the fact that in the absence of a property, then landlord-tenant relationship cannot come into existence. And having said that, it is one thing for a property to be in existence. It's another for one to be legally empowered to create that relationship. Now, what am I trying to say? For one to be deemed to be a landlord in Enugu State, one must have rights over a given property. Right now, I'm in an apartment delivering this lecture. Before I can exercise the rights of a landlord over this property, there must be a law, there must be a right recognized by a law which I enjoy over this property, which is called right of occupancy. And there is something important about the landlord and tenant law of Enugu State. It does not apply to customary to the laws regulating the rights of landlords and tenants as covered by customary law. Just like what obtains in marital relationship. Marriage contracted under the statutes in Nigeria. These marriages are governed by the provisions of Marriage Act. And whenever we are talking about the dissolution of this marriage, we also fall back to the provisions of the Matrimonial Causes Act. Now, the Marriage Act does not regulate the conduct of customary marriage. Likewise, coming to landlord-tenant relationship, customary tenancy is not governed by the provisions of the landlord and tenant law of Enugu State. So basically, we are talking about statutory relationship. Tenancies created expressly by law and by implication. We will still get to that by what we mean expressly by law or by implication. So having said that, as I noted earlier, there must be a property in existence. And the person who wants to assert the right of a landlord must enjoy rights over that property. That right is called the right of occupancy. It is from that right of occupancy that I can now, as a landlord, appoint a third party or empower a third party to live in that property. And that third party will now be referred to as a tenant. In other words, before I can act as a landlord, I must enjoy either statutory or customary right of occupancy over a given property in Enugu State of Nigeria. And in that regard, if for instance I enjoy a statutory right of occupancy, I can now let another person, I can now let in another person to occupy a part of that particular property or the entire property, in which case that person will now be accountable to me. So we have taken a look at the nature of tenancy recognized by law. Having said that, there are types of tenancies recognized by the landlord and tenant law of Enugu State. One, you have the yearly tenants. And these are people who are tenants by virtue of the nature of the agreements which they entered into with the landlord. In which case, by virtue of the consideration which they give to the owner of the house, being referred to as rent, they pay rent on yearly basis. These are called yearly tenants. We also have monthly tenants. These are tenants that pay rent on monthly basis. We also have even have a yearly tenant, those who pay rent on 6 months basis. We also have those who we refer to as quarterly tenants, those who pay rent every 3 months to the landlord. Now, apart from this ambit of the law, there are types of tenancies created. For instance, there are tenants who become tenants at will. There are those who we refer to as tenants as sufferance. But we will not go into details at this juncture because many of us may not be able to appreciate the details. If you're talking about tenants at will or tenants as sufferance, you may do good to consult your lawyer. Your lawyer will explain these types of tenancy relationship for you. Okay, so having raised some of these vital issues, the fourth issue we are going to look at is the terms and conditions expected to be part of landlord-tenant relationship or agreement. Terms and conditions expected part of landlord-tenant relationship or agreement. One thing I have to make known to us at this juncture is that a tenancy relationship must not be in writing. It mustn't be in writing. But it is desirable that such relationship should be in writing. A landlord-tenant relationship can be created orally by agreement of both parties. But you know one thing with oral relationship, it will be your word against the other person's word. In other words, if I am a landlord of a property, or if I am a tenant and I enter into a landlord-tenant relationship in Enugu State with a tenant, and the terms are not put down in writing, in the event a dispute arises, we may have challenges as to the terms and conditions which we agreed on at a particular time that relationship was being created. Unlike when everything is being put down in writing, then the parties will be able to say, look at what we agreed on, that we have breached particular terms of this relationship, in which case either of the two sides to the agreement can claim damages against the other as envisaged by law. So tenancy agreement mustn't be in writing, but it is desirable to be in writing. Having said that, I have to accord attention at this juncture to the terms and conditions expected to be part of a landlord-tenant relationship. And why saying this, it mustn't be a landlord-tenant relationship that is in writing. It also applies to landlord-tenant relationship that was reached by parties orally. But as I said earlier, it is one thing to reach an agreement. It's another to establish the fact that such an agreement, that there are such terms and conditions form part of the agreement reached by parties. Now, having said that, one of the vital terms and conditions that the property which form the subject matter of the agreement must, be habitable. Because as human beings, we are expected, as creatures that have dignity, to live in a decent environment. Now, there are some buildings that are not newly built. So you don't expect such buildings to be totally in order. But just like what is being said in commercial transactions, that a car is roadworthy, a property is expected, a property to be inhabited by a tenant is expected to be habitable. And there is a corresponding duty imposed on a tenant, to leave the same property in a tenantable condition. Because I will still come to the issue of biases, biases people normally hold against landlords and even tenants. So it's expected that if you move into a property as a tenant, one, that the property should be in good state. Likewise, while leaving the property, you should also leave the property the way you met it. In worst case scenario, it shouldn't be worse than you met it. In other words, if you move into the property or the property given to you by a landlord, you acquire that possessory right, the right to make use of that particular property. But while doing that, there is a duty imposed on you by law to also ensure that the property is kept in a tenantable state. When we say that a property is to be kept in a tenantable state, in Igbo land we say that eboe onye biko na awachi. Just like if you procure a tricycle, what we refer to as keke, on a hire purchase basis, you are expected to be keeping that keke in a good state. There are a few things that may get spoiled in that keke. You don't expect the owner of that tricycle to come and fix it for you. I'm not talking about fundamental damages that may be covered by insurance policy. I'm talking about, let's say, refilling the oil of that tricycle, ensure that that tricycle is in good state, the way it was given to you. Of course, the owner of a tricycle should not expect his tricycle to be in the same state that it was when it was given to an interested rider. Yet, that same tricycle is expected to be in reasonably good state so that if it is given to another person, the person will also be able to enjoy it. It also applies to landlord-tenant relationship in Enugu state. And because a crisis may erupt when the tenant wants to leave a premises, it's advisable that, if possible, in theory, I know I'm saying in theory, if a tenant is moving into a property, you can take photographs of the property, to have evidence of how the property was at the particular time you moved into it. And there should be evidence that the particular photograph was taken at the particular point in time when you moved into that property. So that in the event any dispute arises as to the state of that property, you'll be able to lead evidence to show no, that I did not spoil this man's property or this man's property as claimed, that this was the state of the property at the particular point in time I moved into this property. It also applies to landlords. That's why in some tenancy agreements, and as a matter of fact, this is what we prepare very well in this law firm, comprehensive tenancy agreements. In tenancy agreements, most landlords will always put a clause there in the agreement that will help ensure that the tenant has inspected the condition of the premises and that the condition of the premises is in a good state. Another vital terms and conditions that should form part of every landlord-tenant relationship is a wide enjoyment of the property by the tenant. Yes, you may be the owner of a house, but once the tenant moves into that particular house, that tenant acquires what we refer to as possessory rights over that property. And in law, it is said that possession is 9/10 of the law. What do I mean? Anybody who is in possession enjoys rights recognized by law. That is why even as a landlord, if you move into your tenant's property without his consent or approval, the tenant can hold you, go after you for the thought of trespass. But there is an exception to the general rule. That exception is this: the landlord and tenant law of Enugu State also envisages that there are some circumstances whereby a landlord of a house will have the right to inspect the condition of his property. To know if there is any illegality going on, or to be sure to inspect the condition of his property, to ensure that it is not being used for any illegal purpose, or to ensure that his property is not being mismanaged. But despite the fact that the law empowers a landlord to do the same, it does not mean that the landlord can just wake up in the morning and then move into a tenant's property. No. First of all, such a visit has to be done during the daytime, unless the tenant intentionally, which has been backed up by evidence, intentionally decides to make it difficult for the landlord to have access to the property in the daytime. And secondly, the landlord is expected to give the tenant prior notice. You can't just come to the tenant's house, then tell him, yes, young man, I want to. No. You have to give reasonable notice, at least for some hours, that please, be coming, or gentlemen, be coming to this premises on so day to supervise the premises. And the funny thing is this: whenever a landlord gives prior notice that will be coming to inspect his property, some tenants tend to fix certain things that they may have spoiled in the property. The landlord will be coming around to inspect the property. And now the rule against, against trespass does not apply to criminal activities. So law enforcement agents, subject to their procuring warrant of arrest, where the law investigates that, or in the event that an offense is being committed that does not require a warrant of arrest for a tenant to be apprehended, that particular rule could be violated, because one thing about law is that to every rule there must be an exception. So apart from this exception that I highlighted, it is a general rule that once a tenant is in possession of a property, he should be allowed to enjoy quiet possession of that property. He is a tenant, yes, but he's in possession. And there is reason for him or her being in possession. You have the right to go after him or her in accordance with the provisions of the law. Now, another fundamental terms and conditions, one of the fundamental terms and conditions is the issue of rent. Rent mustn't be in cash. It is subject to the agreement reached by both parties, even though normally it's usually in cash. The parties stipulate how much to be paid by the tenant. The tenant pays rent, and in paying rent, the rent ordinarily should be paid directly to the landlord. Anybody the landlord may appoint in that regard. And upon paying rent, receipt is to be issued. Receipt is to be issued. Receipt is the entitlement of a tenant. However, this issue of receipt, there is an issue that has to be clarified. There is what we call mean profit. Mean profit, in due course, hopefully one of my colleagues will still handle it when we talk about the determination of tenancy. Mean profit is the money you pay a landlord after a tenancy must have been determined. So before a tenancy is determined, any money you pay to the landlord is called rent. But once a tenancy is determined, the money you pay the landlord is now referred to as mean profit. How is a tenancy determined? Ordinarily, the law creates provision for the manner in which tenancy is determined. But when we say that the tenancy has determined, it means that ordinarily, in the legal balance, ordinarily means that either the landlord or the tenant has formally brought the tenancy to an end by issuing notice to the other party. Whenever we talk about notice to quit, people think that it's only landlords that issue notice to quit. No. Tenants do also issue notice to quit, but in this scenario, they can serve the landlord with notice of their intention to give up possession. I know it's not common, it's usually rare. So in other words, on the one hand, a landlord can give a tenant notice that, look, I want to recover these premises. That's notice to quit. Likewise, on the other hand, a tenant can also decide to say, I'm giving you notice that I want to quit. I am giving you notice that in 1 month time or in 2 months time, I'll be leaving this property. So when that happens, it is deemed that a tenancy has been determined. That's why ordinarily, once a landlord issues and serves a tenant with notice to quit in the Enugu state, the mistake some people normally make is that automatically they stop paying rent. Yes, in the eyes of the law, you stop paying rent, but that does not mean legally you should not be paying your landlord money. But that money you're not paying the landlord will not be referred to as mean profit, in which case an endorsement ordinarily should be made on that receipt to be given to you thereafter as mean profit, no longer as rent. Even though what some people do is that they stop paying, hoping that by the time they are through with litigation, because it is when the court must have been through litigation that the court will now make a pronouncement. That's when the landlord can now go after the tenant to recover the entire money. Even though what happens in reality is a different issue altogether. So, as I noted earlier, rent must form a vital part of that relationship, the terms and conditions. It stipulates how much to be paid when the tenancy is to last. In case of when the tenancy is to last, you now stipulate whether it's tenancy for a term setting. When I mean tenancy for a term setting, I can say that this tenancy starts from the 1st day of January 2023 and ends on the 31st day of December 2023, being a tenancy for a term of 1 year setting. It can be a yearly tenant, it can be a monthly tenant. You have to stipulate the nature of the tenancy. Then there are other numerous conditions to be stipulated. Most landlords will tell you that in the tenancy agreement, which they've entered into either orally or in writing, that I will not like you to come in back late at night, that so and so time that you are entitled to make use of your musical equipment in entertaining yourself, but it shouldn't be used in such a way so as to constitute nuisance to other tenants. Likewise, one of the conditions may be that in keeping the premises clean, that the tenant is to participate, is to join hands with other occupants of the premises in keeping the premises clean. Likewise, the facilities to be used or to be enjoyed by the tenants. Now, if you take a holistic look at the provisions of the Landlord and Tenant Law of Enugu State, it didn't stipulate the nature of facilities that should be enjoyed by tenants, but there are basic facilities that must be enjoyed by a tenant. For instance, the issue of access to the property. You cannot give a tenant, you cannot let giving property to a tenant and then make it difficult for the tenant to have access to that particular property. It is mandatory there must be access to that property. Otherwise, the essence of the tenancy will be deemed defeated. Now, some persons normally ask questions, what about facilities like pipe-borne water, electricity, utility bill? The truth is this, there is no express provision in the law, Landlord and Tenant Law of Enugu State, that the landlord must avail the tenant of these facilities. However, it is subject to the agreement reached by parties. Because in law, it is said that pacta sunt servanda, agreements are binding. And that's the beauty of having tenancy agreements in writing. What am I trying to say? Assume there's a contractual relationship between both parties. And in that contractual relationship, it is provided that the landlord is to make provision for water supply in the property, then automatically it becomes an obligation. But if it is not contained here, it is not an obligation imposed on the landlord because it does not form part of that relationship. And unfortunately, in this part of the country, the basic essentials needed to make life comfortable, like pipe-borne water, even electricity, these essentials are being showed up basically by the government of the day. But here in Nigeria, even in the Enugu State, the story seems to be different. So if you want to enjoy some of these additional rights, it should be contained in the contractual agreement. Once it is contained, you can enforce it against the landlord. In other words, if the landlord in the agreement agreed, which entered into with him, agreed that there will be provision for water supply in the premises, and he fails to keep to that promise, you have the right to go after him because it will amount to a breach of the contract entered into. And before I proceed further, coming to the issue of rent, normally the parties can also agree on how to pay rent. Ordinarily, rent is paid in arrears, but the parties can agree to pay you rent in advance. That's why, for instance, in case of monthly tenancy, a monthly tenant usually pays rent at the end of the month. However, going by the agreement, a monthly tenant can decide to pay rent in advance. That's a very beautiful agreement. And that's why I raised this issue earlier, that it's very, very beautiful for parties to have the written document, being landlord-tenant agreement, that will embody, the yearnings and desire of both parties. But in reality, we are having some challenges in Nigeria, especially in the Enugu State of Nigeria, the issue of accommodation. We are battling with the challenge of scarcity of accommodation. So in reality, it will be difficult having a tenant trying to, insist in having most of those things, except for tenants who live in choice areas. There are some parts of Enugu where you rent a property, automatically you expect to have some of those facilities there. Even if there is no water supply by the government of the day, in such facilities, especially considering the type of rent you pay, you expect the landlord to make provision for water supply. But expecting the landlord to make provision does not mean you expect him. It has to be in writing before moving into the property. Before moving into the property. And again, it's also advisable for a tenant, before I move into any property, examine that property. The few properties I manage, I normally do it. I do advise tenants, go and examine that property because some of them may not be very beautiful places. They may not be in choice areas in the state. So go and examine the property, examine the facilities there. It's not about just paying money to the landlord, no, of the property. You have to look at these facilities to be sure that that you are satisfied with them. So that not tomorrow you come back and start saying that this is not there, this and that is not there. No. Because many people, when they are looking for accommodation, they tend to be in a haste just to pay to secure accommodation. But some of us, despite the fact that many planning for accommodation, still insist that prospective tenants should go and examine the property where they want to move into. That comes down to the issue of even a utility bill being paid. The manner in which it is to be paid will be stipulated, like paying for the free power supply. And these are part of the challenges some landlords do encounter, because in law, presently as it stands in Enugu State, the company saddled with the responsibility of providing power supply normally holds the landlords responsible whenever any property is indebted to them. So that's why some landlords also put some clauses to ensure, and also put in place some measures to ensure that tenants who live in their property don't owe them. When I mean they don't owe these power companies that supply power to premises. And the manner in which energy is to be paid for could be stipulated in the agreement. Luckily for us these days, some of these buildings now have prepaid energy meters, in which case tenants pay for the energy consumed in their property. So these are some of the few terms and conditions expected to be contained in any landlord-tenancy relationship. There are many of them. When you pick up a copy of tenancy agreement prepared by this law firm, as I noted earlier, we normally couch well-detailed tenancy agreements, and it's also advisable to landlords, same as tenants, before you allow any tenant into your property, you should conduct underground check. Likewise, as a tenant, before you move into the property of any landlord, also conduct underground check to know if the landlord or the tenant is someone you can live with, because some landlords are very troublesome. Some tenants are also very troublesome. One of the most difficult areas of law to handle is the landlord-tenant relationship. And we'll still come to that. Biases, prejudices, people normally hold against landlords and against tenants, even though most landlords seem to be at the receiving end because of the other dog syndrome. But from years of practice, there are many wonderful landlords and there are many horrible landlords. Likewise, there are many wonderful tenants and many horrible tenants. So it is advisable to judge every given individual on personal basis. But at times, some of us tend to exhibit underdog syndrome. Whenever anything goes wrong, you tend to look at the landlord as the wicked person, without necessarily trying to find out, to know the person who is actually at fault, to know the person who is right or wrong. You see many landlords, the way they complain, the way they cry bitterly over the manner in which their properties are being handled. Just like what some commercial bus and tricycle riders do, the way they handle tricycles and buses that do not belong to them. People tend to accord attention, or people tend to present what personally belongs to them, unlike what belongs to another person, which is an unfortunate behavioral pattern. Just like what happens in Nigeria, most government establishments, people tend to take it as public property. They don't tend to protect government establishments. But whenever they have their own personal business venture, they tend to accord much attention to it. So at times, you find some tenants, they move into property, they tend to misuse it, they destroy all the facilities. Even when the landlord must have put those facilities in place, they tend to destroy those facilities. Why also expecting the landlord to be repairing those facilities? Even some people do it mischievously. They will intentionally destroy so sorry for the little distraction. They will intentionally destroy facilities in the premises where they reside, while hoping the landlord to repair same, so that indirectly they'll be paying rent with one hand and using the other hand indirectly compelling the landlord to spend on the money that the landlord receives from them. These are some of the challenges some persons witness in course of managing property. And I come across some former tenants. When they were tenants, they used to complain bitterly about landlords. But when they became landlords, they are compelled to guard jealously their own property. In fact, they became more wicked than their former landlords. They became more wicked in quote. But we are going to get some of these issues. But in a nutshell, the manner in which we can solve some of these problems is by ensuring that the terms and conditions, the ambit of the relationship which you want to enter into with the landlord is well stipulated. Anything you want, let it be in writing before you make any payment. This is what I want. The landlord will also say, okay, this is the one I want. This is the one I can do. This is the one I can do. Look at the facilities I have in my property. Yes, I have some and so facilities, but you must ensure that these facilities are well taken care of. The ambit of that relationship will be well stipulated. That is why it is very, very much beautiful to have a well-couched and well-prepared tenancy agreement. Because the interesting thing about the landlord and tenant law of Enugu State is that it is subject to the agreement to be entered into by parties. So that law has an exception. That law is not totally binding. Let me not confuse us. The landlord and tenant law of Enugu State is operative in Enugu State. There are some provisions of that law that even by agreement, you cannot waive those provisions. However, the law gives you the free will, the free hand to say, okay, that we can agree on so and so things, like the length of notices to be given in determining the tenancy. For instance, under common law, for you to determine a yearly tenant, you have to issue 6 months notice to quit to the tenant. 6 months notice to quit, which notice to quit will expire on the eve of the anniversary of the current term. However, if there is tenancy agreement, you can decide to reduce it even to a month or even to 2 weeks, if you like, once it is in writing. Now, going by the provisions of the common law for monthly tenants, it is a 1 month notice to quit that will be issued in determining the monthly tenancy. Yeah, parties can even decide to increase it. So, to make all these things to be easy, the terms of the agreement, the terms of the relationship should be stipulated. Likewise, there is another vital term that should form part of every landlord-tenant relationship. The relationship must not be used for perpetrating illegality. In other words, I cannot create a landlord-tenant relationship in which my premises will be used for kidnapping. It will not stand, or for any other immoral purpose, illegal or immoral purpose. It will not fly. The court will tell you no. It will become void ab initio. Ab initio means from the word go. Even though you may claim that a landlord-tenant relationship has been created, but once the law is made to be aware of that particular development, the law will deem it that no relationship is in existence. Sorry. Because landlord-tenant relationship must be created for a legal purpose, not for any legal purpose. Now let's move further to a very contentious area, being the legality of lawyers and agents being in creating tenancy relationship. Now let me explain something. Let me start with agents. The law, landlord and tenant law of Enugu State, provides that a landlord can appoint an agent. A landlord can appoint an agent to create a landlord-tenant relationship on his behalf. Now, I know the type of agents we see in Enugu. These are professional agents. Professional agents. Some of them are not even being specifically appointed by landlords. There are some landlords who have specific agents. They can say, okay, I've appointed you, Mr. Okeke, to be my agent over this property. Mr. Okeke will discuss with prospective tenants, bringing those prospective tenants into the property, and even enter into a landlord-tenant relationship on behalf of that landlord with the tenants, and the relationship become binding. That is what the law envisaged in the landlord and tenant law of Enugu State. However, to the best of my knowledge, I don't think there's any law that expressly prohibits the operation of agents as we know it. As a matter of fact, some landlords don't even like working with agents. That's the reality. I manage properties. Some landlords don't care. But some landlords, whenever they hear anything agent, they say no, we don't want agents for some reasons. Because agents are business people. Most of them are just interested in the monies they want to get. They can bring in anybody, try to force the person on the landlord, collect their own share and go their way. But in an ideal society, the landlords who are not money driven are usually reluctant in giving out their property to people. Because in the days of yore, landlord-tenant relationship is not just even purely seen as a commercial relationship. It's like a brotherly relationship because you are going to stay with that person in your property. That's why if you look at some properties, there are some tenants who have stayed a very long period of time with landlords in their premises. In which case they now operate as if there is just a minute, please. Just a minute. So sorry. So in which case they now operate as if they are brothers. It's not just about giving out property, collect money, no. So some landlords are reluctant in giving out their properties to agents to manage. Now, to the best of my knowledge, subject to any contrary information, there is no law that expressly prohibits the operation of these agents. You know, they are professionals in their own enclave. But I think the government of the day should come up to make it formal, so that the rules and regulations guiding this relationship, you know, to prevent, to curtail the challenges most prospective tenants normally encounter in having access to properties. These are the realities we have to face. You know, the essence of this lecture, to a great extent, we are trying to be dispassionate because we are conversant with the workings of this particular field of law without sounding immodest. So we wouldn't like to sound utopian, or we wouldn't like to sound in such a manner whereby maybe landlords will see us as good people or tenants will see us as good people. We are trying to look at the law and also the reality on ground. If you say that you want to just come after tenants that way, after agents, property agents that way, you may have difficulty. You may have difficulty in addressing the situation, especially considering the challenges of the moment in this state. They may go underground. They will keep operating. After all, someone will be in need of an apartment. You don't know how to go about it. They are the ones that will help, you know, lobby, take you to a place, show you an existing accommodation. And there are also landlords, as I said earlier, who don't even like working with them. So what I think the government of the day has to do in trying to address the housing challenges we have in the state is to take a look at the realistic policy, whereby the government will say, okay, that maybe for the time being, stopping these people will be difficult. Not that they are above the government. No, no one can be above the government, but let us make this to be more formal. Let us make it to be more uniform. Okay, look at the caliber of charges that should be charged by any agent, and the association must be registered with the government of the day, and the activities regulated. You know, any form of undue extortion checkmated, you know, so that and the caliber of fees to be charged to be made moderate, to ensure that prospective tenants are not made to undergo unnecessary difficulty. You know, it's becoming a very big issue finding accommodation these days in Enugu State, which is not part of what you are looking at, because the factors behind this unfortunate development are myriad. You know, demand outweighs or exceeds supply. That's one of the reasons, and also the culture of greed, which pervades virtually all facets of our existence as a people. Not only existing among lawyers, landlords, and agents. No, some of us complain and cry bitterly about the activities of agents and landlords and lawyers, if you should tell yourself the truth, you find out that you also exhibit greed to a great extent in your own field. Just like what happened some weeks back in this country following the CBN cashless policy, some POS operators became kings in the land. So I am not trying to justify evil. I will never do that. But I'm just being realistic. I'm just making it known that many of us are complicit as far as this issue is concerned. So in a nutshell, I think the government of the day should regulate the activities of agents to make it more formal. Now, coming to the issue of lawyers, the law also does not provide expressly that lawyers should be involved in creating a landlord-tenant relationship. However, the landlord and tenant law of Enugu State empowers a landlord to appoint an attorney over his property. And now, interestingly, an attorney must not be a lawyer. And I have seen instances whereby landlords appointed even laymen. When I mean laymen, I mean those who are not lawyers. So it is not being used in a derogatory term, not at all. Or against non-lawyers, some landlords appointed non-lawyers to even act as their attorneys. But why most landlords normally prefer using lawyers is that whenever there is any legal issue, to be handled as it concerns that property, such lawyers who are appointed as attorneys tend to render legal services to the landlords. That's why most landlords prefer appointing lawyers as attorneys. So the law does not prohibit landlords from appointing lawyers as attorneys. And these lawyers being appointed can come in and enter into a landlord-tenant relationship on behalf of their principal. The principal is not the landlord, the owner of the property. But any action being taken must be for and on behalf of the principal. So the lawyer will not step into the shoes of the principal. No, the lawyer will rather be acting on behalf of the principal. And in which case the principal has the powers to say, okay, I'm done with you. Let me look for another attorney. Now there is a contentious area, and many of us may be itching to ask that question: the issue of charges by lawyers. So we always tell you about the issue of 10%. Now let me clarify this ambiguity. The 10% in this regard of a truth is usually between the landlord and the lawyer. The landlord and the lawyer. If you go through most relationship created in this regard, the landlord will stipulate how much is to pay a lawyer for the services rendered. But the money is normally collected by lawyers when a tenant is moving in. Is the money they are collecting on their own, or in fact they are on the same force with agents. They collect such monies on the same force with agents, except for lawyers who were engaged on a neutral note, either by the landlord or by the tenant, to prepare a tenancy agreement. Let me explain. You may consult me as a lawyer. Maybe you want to move into a property. As a tenant, you can consult me as a lawyer and say, please, I want to move into a property. Help me couch a tenancy agreement that I will present to my prospective landlord, even though most landlords will hardly accept that. Or a landlord may also engage a neutral lawyer. A landlord may approach this office and say, Mr. Ome, there is a tenant which I would like to move into my property. I would like you to prepare a tenancy agreement for the prospective tenant. That landlord cannot pay me my professional fee. How much he's going to pay me will now become a personal agreement that I'm going to reach with him, subject to the provisions of whose professional conduct. Likewise, if I was consulted by the tenant in that regard, the tenant will also decide how much to pay me based on the agreement I will reach with that tenant. So the issue of 10% is purely the relationship, because it becomes a continuous process. Let's say after the tenant must have moved into the property for the first time, while paying subsequent rent, the tenant ordinarily does not pay the lawyer any amount of money again, apart from the normal house rent the tenant pays. So it's from that normal house rent that the tenant pays that the landlord of the house is expected to be remitting 10%, if that's what they are agreed on, to the landlord and to the lawyer for the services being rendered by the lawyer, in taking care of that property. In other words, that money being paid that first time, I wouldn't really say that it's really good, but is the money a lawyer will collect for his legal knowledge, which admittedly is usually on the high side. And it's also necessary that the government of the day should come in and wade in to make it, formalize it. The relevant law should be amended. Say, okay, look at the caliber of our money that should be collected from a tenant who is moving into a property, who consults a lawyer. You know, the issue of 10%, for instance, 10%, not even only 10%, some percentages accrue to a lawyer if involved in property transaction. Assuming someone wants to sell a plot of land, there's a particular amount of money that a lawyer is expected to pay, and the percentage changes based on the amount of money involved. But in this landlord-tenant relationship, that money you are paying for that first time, you are not paying it based on the fact that the lawyer is an attorney to the landlord. You are paying it to the lawyer, usually on the prodding of the lawyer, because the lawyer has access to that property. If I want to sound utopian, if you just want to clamp down on the lawyers, then we are not trying to be realistic, because they will definitely know how to circumvent that particular issue, especially considering the fact that many people are in need of accommodation. Many people will be willing to pay the money. And I agree, it's now on the very high side. When you combine the money being paid by landlords, paid to lawyers and agents in Enugu, it is on the very, very high side. And the way to go about it is for the government of the day to come in, to become more strict, to put in place policies to reduce this amount of money and then enforce it. If you want to phase it out entirely, then I don't know, it's possible, but I doubt if it will be possible to do same at this juncture, considering the number of persons in need of accommodation. And I know what I'm saying, people will always find means of circumventing that particular provision of the law. However, if you reduce the money and then enforce it, if you make it more realistic, whether lawyers like it or not, whether agents like it or not, you now enforce it. We all are human beings. Those who have conscience will be compelled to comply. Just like when the rent tribunal was still very, very much effective here in Enugu State. You know, the landlord-tenant relationship is governed by capitalist outlook. When I mean capitalist outlook, it's governed by the forces of market forces of demand and supply. This is not a socialist economy. The government cannot dictate for landlords how much they have to collect as rent from tenants. However, when the rent tribunal was still inoperative, very much effective, contrary to this same landlord and tenant law of Enugu State, at times the government of the day will stipulate the amount of money to be paid for a given type of property in a given location. Let's say the government will say that those living in a Owani area should pay some amount of money. Those who live in 3-bedroom flats in a Owani area or in a Papa area, those who live in low-cost housing, they should, you can decide to charge less than that, but it should be within this price range. And I think that's a very wonderful idea. Likewise, bringing it to the activities of lawyers and tenants, lawyers and agents. If you want to, place an express ban, total ban on it, I'm afraid it may not work out. Rather, what should be done is that the government should not shy away. The government should come in, reduce the prices drastically, stipulate that if you're a lawyer and you are couching a tenancy agreement either for the benefit of the landlord or for the tenant, in a case where a new landlord-tenant relationship is about to be created, don't collect so and so amount of money for so and so property situated so and so place. Don't collect that. And it will become an offense if you collect more than so and so amount of money. But the amount should be reasonable. And likewise, provision should also be made for review. The same way the rent tribunal, when it was operative, was giving powers, when it was very, very effective rather, was giving powers to review the type of rent to be paid for properties situated in particular given areas in Enugu State on an intermittent basis. This is how I think it should be done, for it to be very much realistic and reasonable. Then we now come to the issue of biases and prejudices against tenants and landlords. In landlord-tenant relationship, I've hinted that earlier, most landlords are seen as bad people and most tenants are seen as good people. But it doesn't work that way. Just like whenever we're talking about police, once you mention police, most of us will say that policemen are bad people. But it doesn't work that way. We have citizens who are troublesome. In fact, without the police, there will be lawlessness in the land. Agreed. The police may have their own shortcomings, which are very, very obvious. Yet, we also have citizens who violate the laws of the land. We also have citizens who deal with their fellow citizens. And the police is always there to come in to do the needful, to ensure that there is no breakdown of law and order, to ensure that those who have gone contrary to the provisions of the law, that they are apprehended. Having said that, coming to the issue of landlord-tenant relationship, whenever you hear the word landlord, don't conclude a person is a bad person. In the course of doing my work, I have come across many horrible landlords. You know, they treat tenants as if they are not human beings. Likewise, on the other hand, I've come across many horrible tenants as well, who do terrorize even their co-tenants. Those who are into property management. In fact, there are some persons, some landlords, they don't feel like building more houses because it's usually troublesome managing properties. Usually very, very troublesome. But the general advice I will give to both landlords and tenants with regard to the prejudices, if you are a landlord, you should embrace the golden rule: do unto others what you like to be done unto you. That's the golden rule. Likewise, if you are a tenant, handle your landlord's property or relate with your landlord the way you would love to be related with when you also become a landlord. So, because as a tenant, you mustn't remain a tenant forever. One day you may also be a landlord. So, if you should comply with these two basic rules, you'll be having less difficulty. You know, as a landlord, while charging rent, take a look at the caliber of rent you charge. And that's why addressing this issue, I'm now delving into the area of rent. You know, the amount of rent to be charged is dependent on the agreement between both parties. But the government of the day should also come in this time around, because in Enugu, it's also becoming exorbitant. You know, there should be a deliberate policy, a realistic policy. You know, I've been invited on several occasions to address this issue. This is not an issue you can shy away from, but I'm looking at it from a realistic point of view. The government of the day should take a look at the law, you know, to know how to be more realistic. The government of the day should embark on deliberate steps to, you know, to create more opportunities for building houses in the state. More estates should be created, low-cost housing estates, not necessarily estates for the high and mighty in society, so that there be enough accommodation, so that supply will outweigh demand for accommodation. You know, satellite towns should be created in the Enugu state to help decongest the city, because there is, you know, the city is densely populated, and generally the culture of greed amongst us should be reduced. Both landlords, tenants, Enugu people, Igbo people, Nigerian people, let us generally, and even talking to myself, let us deliberately try to reduce greed. Because as I said earlier, when some people tend to complain about landlords and tenants, ask yourself, you listening to me, in your own little sphere of control, don't you exhibit greed? At times during Christmas season, people tend to, have the prices of their goods and services skyrocketed for no just cause. I know there are those who may skyrocket theirs because of maybe increase in the cost of transportation and other logistics, but there are people for no just cause who, just for the purpose of amassing, amassing wealth at the detriment of the populace, will decide to skyrocket the prices of their goods and services beyond that which they are expected to collect. So, rent tribunal, to a great extent, when it was effective, used to regulate the issue of rent. But to a great extent, going by the provisions of the law now, it is to be determined based on the agreement reached by parties on how much to be paid. And whenever there is a review of such rent, when it should be made, if there should be an increment, when would that increment take place? Will it be at least for a period of 4 years after the last increment was made, or for a period of 1 year after the last increment, at least a period of 1 year after the last increment was made? All these could be stipulated in the tenancy agreement. And once these issues are contained in the agreement, these issues will become binding, and a party can take it up against another party whenever there is an obvious disregard for one of the provisions of this agreement as contained in agreement reached by parties. So thank you very much. To a great extent, I believe I have done justice to some of the issues raised. We are going to meet again next week Monday, same time at 12 noon next week Monday, being the 22nd day of May 2023 at 12 noon, to discuss other issues that border on the rights of landlord and tenants in Enugu State. We are going to look at issues like determination of tenancy, how a tenancy can be brought to an end, and other areas. Just keep in touch. We get to publish it on our page so that you know about other areas that are very, very vital as far as the landlord-tenant relationship in Enugu State is concerned. I hope you enjoy this particular outing, this 1 hour plus. If you have any question, kindly subscribe to my YouTube channel, CD Obe TV. Then underneath the YouTube channel, because this video will be uploaded on that channel in a few days' time, then you type in your questions. We have time to respond to you. You can also feel free to share this particular session for others to also benefit from seeing. So if you have any questions bothering you, you can raise these questions and we have them attended. Thank you very much. We appreciate you for being part of this exercise. And please, very, very sorry for today's outing. Hopefully, the next outing will be more colorful. Some issues came up unexpectedly. And I was like, it's like they're about frustrating this particular outing today. You know, the fittings, the electrical fittings, just a few minutes to the development just went off. And trying to reach out to the person to fix it definitely became impossible because today is Monday and we are observing a sit-at-home exercise here in the southeast, in Enugu State to be precise. So hopefully, come next week, hopefully the issue will be addressed and we'll have a more colorful outing. Once again, I remember my humble self, Mr. Chukwunonso Daniel Ogwe, Principal Counsel, Chukwunonso Daniel Ogwe and Company, Victoria Aseta Chambers, Enugu State of Nigeria. Thank you and God bless you.